Okay, let's begin. This is the law of evidence. And so one of the first things to always be thinking about is where you are in the trial. Recall the order of events of the trial. There are preliminary matters, motions in limine, any existing motion that is out there that the court has to rule on. That's something that you want to take care of first. Then the voir dire, that's when the witnesses are called, the jury is impaneled, questions are asked. They're either removed for cause or they're removed pursuant to a peremptory challenge. Then after we impanel our jury, we're ready to start. And the plaintiff would make the opening statement. In a criminal case, it would be the prosecution who is making the opening statement. Remember, there are no arguments in that. It's just a roadmap saying what the evidence will show. After the plaintiff or the prosecution makes the opening, then the defendant can make the opening statement. Then after that, we are ready for the presentation of evidence. Remember, an opening statement is not evidence. It's just what an attorney is saying that the evidence will show, or the roadmap, the introduction of the case, an overview of the case. All right, after that, we're now ready for the plaintiff's or the prosecution's case in chief. This is where witnesses testify, exhibits are admitted. There's the direct examination, then cross-examination of that witness. After that is rehabilitation or redirect, and then a recross until the judge says that's enough. Remember, the cross-examination is always within the scope of the direct examination. And when we are done with that witness, we're done with that witness for the plaintiff's case. Now, it is possible that the defendant could later call a witness if it wants to go beyond the scope of the direct examination. But we'll be done with the plaintiff's case in chief. At that point, in a civil case, the defendant can file a directed verdict motion. If you're in federal court, it would be a motion for judgment as a matter of law. This is sometimes referred to as halftime. If it's denied, the case goes on. If it's granted, then the case stopped and the defendant never has to put on their case in chief. Assuming that it's denied, then the defendant would put on its case in chief. It would call its witnesses and then do a direct examination. The plaintiff or the prosecution would be able to do the cross-examination. Then we'd have rehabilitation or redirect and recross until, again, the judge would put a stop to that witness. And then we are done with the cases in chief. So the defendant would rest their case in terms of their case in chief, what they're doing. Now, we're not quite done yet because it's possible that there may be rebuttal witnesses. A rebuttal witness is different than the case in chief because a rebuttal witness is called in response to maybe what another witness has said, and just like the name implies, it's there to rebut what that witness has said. So it may not be in part of your case in chief, but if you want to rebut what a witness would say, then you're allowed to do that. So the plaintiff can call their rebuttal witnesses, and of course it's direct and cross, redirect, recross for them. Then the defendant would call their rebuttal witnesses. Now, if there are no rebuttal witnesses, the close of evidence is when the defendant rests their case in chief. If there are rebuttal witnesses, then we still are taking evidence, of course, up until that point. And then at the close of evidence, after the rebuttal witnesses, then the plaintiff or the defendant in a civil case could file a directed verdict motion or motion for judgment as a matter of law, and that would be considered the close of evidence. In a criminal case, the defendant would file saying that the prosecution has failed to carry its burden in producing enough evidence. Then we have the closing arguments. Plaintiff or prosecution will give their closing argument. Usually they will go first, and they have a choice strategically because plaintiff or the prosecution gets to give a closing argument, then defendant has to give the entirety of their closing argument, and then the plaintiff or the prosecution then gets to end. So plaintiff or prosecution, since they have the burden of proof, get to go at the beginning and at the end of the closing argument. So for instance, if there were if the judge gave 3 hours for closing arguments, it would, the plaintiff or the prosecution might say, okay, I'm going to use 1 hour of that 3 hours at first, then let the defendant give their 3 hours, and then the plaintiff or the prosecution will end up with 2 hours. And it's up to them to strategically divide up that time how they would want to. If it's a jury trial, then the judge will charge the jury and tell them what the law is. If it's not a jury trial and it's just a bench trial where the judge is the fact finder, then of course we don't have jury instructions. There will be the deliberations. If it's a bench trial, the judge may decide right there. Usually they'll take it under advisement and then determine what they have found. Oftentimes, though, a judge at that point would know factually what they think has happened, and then once they get the factual determination, right, the factual findings or the jury verdict, then they can issue a judgment, because now that the facts have been determined, we can apply the law to the facts and do the judgment. At that point, after it's all over with, then there might be post-trial motions. The JNOV at state court, judgment notwithstanding the verdict, or in federal court, Rule 50B, which would be the renewed motion for judgment as a matter of law. There could be motions for a new trial, and then also appeals. You would make your appeal afterwards. So those are the events. Remember that with the rules, there are in the series, the 100, 200, 300, up to the 1100 series. And then we have our rules in there. There are 3 articles, though, by way of introduction, that are probably the most important in the law of evidence. And those are going to be the 400 series, the 600 series, and the 800 series. If we looked at the series in terms of a bar graph, at how much a bar review or final exam might test these areas, the areas are kind of small, but as you notice, it's the 400, 600, and 800 series that get more attention. Lately, the 200 and 300 are covered a little bit more by the bar, maybe some of the privileges, but basically the easiest areas for testing are in the 4, 6, and 800 areas. Okay, so those are the more important ones. All right, now let's start out with the 100 series, which are the general provisions. One of these would be that you have to do your objections very early, very quickly, right after the question. If you don't make an objection and the answer comes, then the objection would be in the form of a motion to strike, because you would say that the answer was objectionable. But if you can get the objection out before the answer, then of course the jury never hears it. You don't have to unring that bell, and it's better to object early, right after the question. So you make your objection, or usually you waive your objection. Now it is possible, if there's plain error and it would cause substantial injustice not to hear an appeal based on a legal mistake, then the judge might sometimes allow you, the appellate court might allow you to raise the objection even if you didn't make it for the first time during court. But usually the court wants you to make those objections, or you're going to waive them. Also, whenever an objection is made, it shouldn't be a speaking objection. It should be the kind of objection where you just state the rule, maybe the basis, and then stop. Let the other side respond. Maybe the judge has a question. If there's any discussion that needs to take place, this is where you have to make sure that attorneys don't try to argue the objection and talk about the objectionable evidence, if it is going to be inadmissible, and do it outside, or do it where the jury can hear it. We don't want that to happen. So Usually we want these rulings and decisions to take place outside of the hearing of the jury. Often they'll have what is called a bench trial. The judge will call the two attorneys forward. They'll talk about it. The court reporter will be right there, and they'll discuss whatever they need to talk about it. The objection, it's on the record. Oftentimes the jury will hear some white noise. The judge will push a button and there'll be some noise just to make sure that the jury isn't eavesdropping on the bench conference that's taking place. So it's important that these discussions are made outside the hearing of the jury. And the rules in the Hundreds series talk about that. Under 105, there is limited or general admissibility. General admissibility would be that the evidence comes in for whatever purpose it comes in for. However, if you ask for a limiting instruction, then the judge would tell the jury, use this evidence only for this purpose, which is admissible, and not the inadmissible purpose. For example, if you're doing character, that would be inadmissible. A judge might say, don't use the fact that the person has done this sort of thing in the past before as their bad character, that they're the kind of person that would do this sort of thing. However, under Rule 404B, as we'll see, if you're using it for a non-character, non-propensity purpose, to show motive or lack of mistake, absence of mistake, identity of the person, any of those, and we'll get into those. But it's just to give you an example of how something could come in for a limited purpose. Easier examples would be, say, 407, subsequent remedial measure. You can't use the fact that someone did a repair afterwards to show that they were negligent, and the fact that they made a repair shows that they were negligent. That would be the inadmissible purpose. But the limited purpose might be if the defendant is trying to say that they didn't have control over the area, and you want to show that they fixed the problematic area. Then you could use it for the limited purpose of showing ownership or control. So that's under Rule 5. Also, Rule 106, sometimes called the rule of completeness. You want to just make sure that you don't pull things out of context. So if something is pulled out of context from a document or a recording or anything like that, the other side may be able to argue that in the interest of justice, it shouldn't be pulled out of context, and you should provide, or it should be admitted more in context, perhaps the whole document rather than just the portion you're trying to demonstrate. So that's Rule 106 and the rule of completeness. There are also these limiting instructions. Sometimes they're also called curative instructions. Let's say that some evidence got in that should not have gotten in, but the witness blurted it out before the objection was done, or they do the motion to strike. Then the curative instruction would be to tell the jury not to take into account what they've heard, to not consider that evidence. Again, it's like unringing a bell. Sometimes it's hard to do. If it's a bench trial, then the judge will just tell him or herself not to take that into account as they are deciding. So that's what a curative instruction is. Also, under the rules, under Rule 103, you often have to do an offer of proof. An offer of proof is given whenever an objection is sustained. And if the objection is sustained, then that evidence is not going to make it into the transcript, or it's not going to be heard. Now, if you want to save the issue for appeal, you may want to make an offer of proof to say, well, Judge, I know that you are sustaining the objection, and so you are saying that we can't hear the evidence. However, we want to be able to appeal that issue, and so in order to do that, we want to make an offer of proof to say what this inadmissible evidence would have proved, so that the appellate court can take into account what the evidence is and it can decide if it was harmless error or if it were reversible error. So the offer of proof allows the attorney to put that in. Now that, of course, is going to be outside the hearing of the jury because it would defeat the purpose if the jury heard it when it's inadmissible. But it's still taken down by the court reporter, and we save that issue for appeal so that the appellate court could at least consider that issue. Sometimes it's not important to get the actual testimony if it's clear from the context or it's clear from the circumstances what the evidence would have shown. Then the offer of proof can just be made by the attorney stating what the evidence is. But sometimes it's important to actually get the testimony. So that is why we have offers of proof. Under Rule 104A, there are rules that allow a preliminary admissibility of certain questions. That is, whenever the judge is making a determination as to whether an item of evidence is admissible, that judge can take into account even inadmissible pieces of evidence to make the determination. So if we're talking about item X, that's the evidence that's admissible. Of course, that has to be admissible, but the judge might take into account other things to determine if item X is admissible. And for that preliminary question, they're allowed to do that, and that is a legal determination. Compare and contrast that with Rule 104B, conditional relevance. Conditional relevance is just saying that we will give the issue to the jury to determine an item of evidence, even if you can argue as a factual matter the item of evidence would not be relevant. For example, an often used example would be a car crash where a hubcap from the car crash came off as the two cars collided, and then it was in an adjacent field, and later it was found. And so that hubcap, that tire rim, would be relevant, but only if the factual condition existed that it was the actual hubcap from these cars that collided, and it hadn't been moved since the time of the accident, so that it could be measured, and then they could determine how fast the car was going based on how far the hubcap were removed. Now, the judge would say, well, the hubcap is relevant, but only if it's the actual hubcap. If it's the hubcap from another car, then it would be irrelevant. All right, that's a factual determination. So the judge would say, as a matter of law, it is relevant as long as the factual condition exists that it's the hubcap from the car. Since that is an issue for the jury to decide, because it's a factual issue, then the judge would let the evidence in, the hubcap, and then the jury can do with it what they will. They may decide it's not the hubcap, and then for them, they just wouldn't consider it. It would be like an irrelevant piece of evidence got in, but they would just ignore that. But on the chance that they would find that it is the tire rim, then they would determine that, okay, it is relevant. Now, the jury never makes a relevancy determination. All right, it's only the judge does that. As the gatekeeper, the judge will decide it's admissible. The jury can consider it, and they'll do with it whatever they will. Okay, a motion in limine. Remember we talked about this with the preliminary matters. This is something also in the General 100s that you're able to file. A motion in limine is just a motion written before trial. The federal rules usually say they have to be 14 days before trial. Usually they're sooner than that, though. And the idea is, instead of waiting to fight about an item of evidence and making an objection at trial, and then having to argue it and brief it and have the judge consider it while the jury is waiting and it's during the trial, it's often more efficient to just say, well, we know this is going to be an issue at trial. Let's not wait for trial. Let's deal with it now. We want to see if we can get in these former convictions or whatever it may be. certain evidence or evidence that may be used improperly, and we want to make sure that it's not going to be raised, and instead of waiting and then having to object, maybe the witness blurts out an answer. Let's forget all of that. Let's try and rule before a jury is even impaneled, or at least take the issue up. Often you get better rulings that way because the judge just has more time to think about it, deliberate about it, maybe do some research about it, maybe ask questions, have a hearing on it. And of course, we're not wasting the jury's time because it makes for a more efficient trial. And also strategically, the parties can plan better because then they can have preliminary rulings on whether certain items of evidence are going to be admissible or inadmissible. One might think, well, then why not require this for everything? I mean, we could eliminate all objections at trial if that were the case. And, you know, conceivably that would be great if you could really imagine every conceivable thing that might come up at trial. It's just you can't predict everything. So it's impossible to do that. It would also be very time consuming to try to figure out all of those issues, and some of the things are unpredictable. But to the extent you can predict it, it's a good idea. And to the extent strategically there's certain pieces of evidence you want preliminary rulings on, it's a good idea to raise that through the motion in limine procedure. Okay, so that's for the 100 series. Now for the 200 series, judicial notice. Think of judicial notice as certain propositions, certain items of evidence, certain things that are just so obvious that the rules say we don't have to formally prove this at trial because it's a waste of time. This is kind of a judicial economy idea. Why make us go through and prove scientific facts if everybody knows those scientific facts? And it would be kind of silly to put a person to the proof. So the court can take judicial notice on non-controversial, non-disputable kind of ideas. So any indisputable scientific fact, the law or theory of gravity, that things fall down. Of course, we don't have to have Isaac Newton in there called as an expert witness. And recall the famous apple experiment, how the apple fell down from the tree, thus demonstrating the theory of gravity. Also matters of local geography, that a certain street runs east and west, or that the two streets intersect with one another. That's perfectly fine. The court can take judicial notice of those kind of things. Sometimes a court will take judicial notice of certain laws or foreign laws, that kind of thing. Now, what's the difference between judicial notice in criminal and civil cases? In civil cases, the jury are supposed to take these as true. When the judge tells you you can take this as true, then you can, whether it's matters of local geography or an indisputable scientific fact. In a criminal case, the jury can reject this, kind of the idea of jury nullification, where the jury still gets to make a determination. Now, often they won't actually do this because the judge has instructed them, but they can get away with rejecting the judicial notice that the judge told them to do that. The difference for this is, as we see in criminal cases, we want to give the criminal defendant many opportunities to fight for their liberty. That's why the burden of proof is different. It's the higher beyond a reasonable doubt instead of by a preponderance of the evidence. And we'll see this in other areas with evidence law as well, that often the criminal defendant gets the benefit of the doubt, often as much as possible, and this is one example. Okay, the 300 series. These are presumptions, and the idea is that if you can prove a basic fact, then the judge will say, all right, if you proved A, then we will presume that you have proved B, whatever that proposition is. So, for example, A basic fact may be that a person, if they are missing for more than 7 years, then some state laws will say the fact that they are missing for 7 years, and you can prove that they are missing for 7 years, the basic fact. So you still have that burden to prove that. But once you prove that, then we will give you a presumed fact. And the presumed fact will be, okay, that person, we can presume them to be dead. So what this means is, given that presumption, you can say that a party has proved that someone is dead because they get the benefit of the presumption. All they really had to prove was that the person was missing for 7 years, but since they proved that, then the law in that particular jurisdiction will give them the presumption that the person is dead, and therefore they have proved that. This comes up in life insurance policies. For instance, there's life insurance on them, they've been missing for 7 years, the family wants to say, okay, we think that they are dead, we can't prove it, we don't know whatever happened to them, but we should be able to collect on the insurance policy because obviously they're gone. And the legislature has decided, yes, after 7 years of being missing, we can presume that they are dead. So if you can prove the basic fact, then you have proved the presumed fact for purposes of meeting your burden of proof. Now, there are rebuttable and irrebuttable presumptions. And what does that mean? Well, just what the term rebuttable means. There are certain presumed facts that the law will entitle you to, but if the other side proves evidence going the other way, then that presumption could burst. In fact, it's called the bursting bubble theory, and that is the presumed fact is like a bubble, and we will give you that. If you prove that the person was missing for 7 years, then we will presume that they are dead. But if the other side proves that they are alive and they're no longer missing, then of course that presumption should burst. An irrebuttable presumption would be that someone under the age of 7 years old cannot form the criminal intent to commit murder. So if a 5-year-old got a gun and got even angry and shot someone, we wouldn't go after them for murder as an adult because the presumption would be irrefutable. Even if we tried to put on evidence that the person, even if they admitted, yes, I did this, I had malice aforethought, I as a 5-year-old wanted to kill this person, the law still would say, too bad, it's an irrebuttable presumption. Okay, 400. Now, the 400 series, it talks about relevancy because that's the first rule, 401 and 402. But there are a number of other rules that have to do with relevant types of evidence that nonetheless, and there are many exceptions to these, but nonetheless should be excluded even though they are relevant. And so that's why the rule contains so many provisions, and it's one of the longest provisions. As you notice, like the other ones, they only have Rule 201, 301, 302. They only have a couple of provisions with them, where the 400 goes up all the way to Rule 415. All right, so let's start out with the first one, 401 relevancy. And again, this article is extremely important. There could be a lot of testing in this area, bar exams, law review, or law exams. But to start out with the first rule, to be relevant, the evidence must have a tendency, it can have any tendency whatsoever to prove something that matters in the case. All right, now, what does that mean? Well, one of the first questions you should always ask when doing a review of evidence is to say, is the evidence relevant? There are two types of relevancy, and we'll see these here. Now, the rule doesn't say logical and legal relevance, although analytically this is a helpful way to think about them. Logical relevance, does it have any tendency at all to make a fact more or less probable? Kind of the idea of a brick in the wall. if your whole case, if it's a criminal case, proof beyond a reasonable doubt, that would be an entire brick wall of your whole case showing guilt beyond a reasonable doubt, or in a civil case by a preponderance of the evidence. But again, it's an entire brick wall. To be relevant, it doesn't need to be the entire brick wall. It only needs to be a part of a case, and it can be a very, very small part of the case. It can be a tiny brick in a very large brick wall. But that brick has to have some weight, and that weight is the probative value, the fact that it has a tendency to weigh one way or the other in the case. Now that's the logical relevancy. There's also something called legal relevancy, sometimes referred to as materiality. And the question is this: is it relevant to something that actually matters legally in the case? So sometimes you can think of it matters and try to tie that to the word materiality, but materiality is also that it's legally important. It's legally material to what's going on. So does it matter legally to the case? And this requires you to look at the underlying law that is at issue. So there's some, in addition to us looking at evidence law, we would have to look at some of the other substantive law, whether it be contract, property, torts, constitutional law, whatever it might be. Okay, so for logical relevancy then, does it tend to prove something? And this is a very low standard, pretty easy to meet, right? There can be links in an inferential chain to get to whatever you're trying to prove. So again, you don't have to prove the ultimate, hey, this person is guilty of murder. But one of the links in the chain might be that the murder was committed with a knife. This person has a knife that is similar to the murder weapon or the wound that was made in the murder, and it was in their locker at work, and the person was killed at work. Now, just because someone has a knife in their locker at work doesn't prove that they murdered them. That would be the entire brick wall. But the fact that they have a knife in their locker, the knife, and it's similar to the knife that appears to be used in the murder, that would be a brick in the wall. So it would form a plausible story. It would have an effect. Another example is flight from the police relevant to a bank robbery. And you could argue, yes, there's relevancy there because it shows a guilty conscience. It has a tendency to show, oh, the person must have been guilty of the bank robbery. That's why after the bank robbery occurred, they were running away. The fact that they were running away and they were running away from police, that flight was showing that they knew they had just committed the bank robbery and they were trying to get away. Now, the defense could come and say, oh no, it's completely irrelevant that they were running away. They were running away only because they're afraid of police. In fact, their brother was a victim of police brutality, and the defendant also had been victimized by police. And so when they saw the police coming toward them, they got scared and they ran away. So it has nothing to do with it. It's irrelevant. Don't fall for that mistake, because although you can argue an interpretation of that evidence, the evidence is still relevant because it can be used. It has a tendency to show something that matters in the case. Okay, so it still points to something. Let's say that blue circle represents the flight, or the fact that the witness, or the defendant ran away. Now, it could point to them being guilty. Why? They had the guilty conscience. They ran away because he committed the robbery. That's what the prosecution would be trying to say. Now, the defense would be trying to say, no, it shows to the fact that they're not guilty, because he only ran away because he was afraid. It was completely irrelevant. This is not like algebra, where you can just cross out the numerator and the denominator. They cancel each other out. These arguments show that it is relevant. It's relevant because it tends to prove something, either way, that matters in the case, and therefore it's relevant. Something that would be irrelevant is if it has nothing to do, whatever, with the person running away, right? It doesn't prove something either way in the case, and therefore it doesn't matter at all. All right, it hasn't, and sometimes that's difficult to think of what would not matter. Okay, so let's talk a little bit more about logical relevance then. It must support your theory of the case, and think of it as, does it form a plausible story as to what must have occurred? How sound is the reasoning from one link in the chain of inferences to another? Make sure you have that logical relevancy there. Okay, so if someone asks, or a witness answers and says that they're a Leo or some other zodiac sign, and that tells something about their personality or something, that could be very irrelevant, whatever their zodiac sign is. Although you can imagine situations where it might be relevant because of certain assumptions people are making, or it might provide certain motivations, and therefore it would become relevant in the case. In fact, one of the things to do in all of these situations, when you go through each of the rule, try to create your own hypothetical that fits within the rule, and then change the facts of your hypothetical so that it is outside of the rule. In other words, see what the rule is, then create a hypothetical and say it would be admissible under the rule, then try to change the facts slightly so that it becomes inadmissible under the rule. And that is a helpful way of providing your ability to recognize situations. You're not just memorizing the rule, but you're trying to recognize situations. Here's an example in the Trayvon Martin Zimmerman trial that took place years ago, where there was an individual who came and they got into a fight, and then he ended up shooting Trayvon Martin. Remember, this is the case that sort of brought a lot of attention to this issue. He had a hoodie on, and that was seen as something that did that scare the individual. And so you might start asking questions like, was it relevant that he smoked pot? Well, what does that tend to show in the case? Does it show anything that matters in the case? Is it relevant that Zimmerman used the N-word? Well, now that could show possible motivation if this were a racially motivated crime. Was it relevant if Zimmerman had been carrying an illegal firearm instead of a legal firearm? Remember, he was talking about using the firearm as self-defense, and whether it was legal or illegal, should that matter when it goes to the self-defense defense? Does it have either a logical or legal ramification in the case? Okay, a little bit more about legal relevance. Legal relevance is the idea that it must relate to your legal theory of the case. If it doesn't relate to your legal theory of the case, one of the elements of the claim or defense, then it's not material in a legal sense. So it has to legally matter. Now, this depends on the underlying substantive claims or charges or defenses in the case. For example, if a defendant thought that a rape victim was 21 years old and not 16, would that be relevant in a statutory rape case? Now, it would be logically relevant in that it's explaining a plausible story and what happened, and it may be part of the defendant's defense. But remember, in a strict liability crime, and this is why you have to look at the underlying law and know some of the legal requirements, but in statutory rape, it's a strict liability crime. That means it doesn't matter if the defendant reasonably thought that the victim was over the age of consent. That's the thing about that kind of thing. And they sometimes this is in these kind of crimes where you'll hear ignorance is no excuse of the law. You're still guilty of it, whether you intended to commit a crime or not, because you fulfilled the elements. So it would be legally irrelevant that the defendant thought that the victim was over the age of consent. It would become legally relevant if this were not a statutory or a strict liability claim, or if the jurisdiction provided for a legal defense of reasonable mistake. Because if the provided for the defense of reasonable mistake, now it becomes material. Now it would become legally relevant what the defendant thought, because that would go to a recognizable defense. Okay, Rule 403. This is our first exception to Rules 401 and 402. 401 requires that it's relevant evidence. 402 simply says that irrelevant evidence will be inadmissible. So when we get to Rule 403, what does that say? It is an attempt to ensure that the jury or the fact finder, but usually it's the jury because the judge knows how to make a distinction between danger of unfair prejudice and probative value. But the idea is that the judge makes sure that the jury only hears evidence that allows it to make a fair and rational decision. What we don't want to have happen is for the jury to get sidetracked with any unfair prejudice. Now, danger of unfair prejudice is the main danger under Rule 403. But don't forget about the other Rule 403 dangers, such as delay, confusion of the issues, where you're causing the jury to be misled, presentation of cumulative evidence. The rule provides for other possible dangers, but usually when we think of Rule 403, we think of the danger of unfair prejudice. So, Rule 403 is a subjective, discretionary balancing test for the judge. The judge makes this balancing test and determines whether something is going to be relevant or admissible. Now, what's the first thing that the judge takes into account? Whether or not there is relevant evidence, and you can think of relevant evidence as, hey, if it's legally and logically relevant, it is a brick in the wall. If it's a brick in the wall, it has some weight. Weight is the probative value of the evidence. So you take the probative value or the relevancy of the evidence, the weight of that evidence on one side, and you weigh that against the danger of unfair prejudice or undue delay, confusion of the issues, misleading the jury, wasting time, all of those 403 dangers. So remember, it has to be unfair prejudice when we're talking about prejudice. Now, if you think about it, just the term prejudice is okay. In fact, prejudice by itself, that would actually fit within the probative value. In other words, if something didn't prejudice it one way or the other, it probably wouldn't even be relevant. So we're not concerned about prejudice per se in the way this is being defined. It's unfair prejudice. It has an unfair effect, and therefore that's what we're worried about. That legitimate prejudice of probative value versus the illegitimate, unfair prejudice or probative value, and that's what you're weighing against one another. Also, the judge doesn't need to prove this beyond a reasonable doubt or anything. All the judge needs to find is that there is a danger, a likelihood, a possibility, a potential of this occurring. And so if there's the danger of the unfair prejudice, then the judge might say, all right, if there's a lot of it, in fact, if it substantially outweighs the probative value, then I can decide that the evidence is inadmissible. Even though it has some relevancy, even though it has probative value, it will still be inadmissible. So think of a balance, and on one side you put the probative value, and remember, it's a brick in the wall, it's something that has weight, either legal and or logical relevance, And you put that on one side, and it's for the jury to consider because they would weigh that. But before that gets admissible or determined admissible by the judge would say, but what about the danger of unfair prejudice or the other possible dangers that under 403? The judge would weigh that. And let's say that is a lot. And the reason for the diagram here is to show you this categorical relationship, because you have to do balancing and a comparison. That is, the judge has to do it. So that little yellow brick in the wall, that little yellow probative value that doesn't have much weight, seems to be substantially outweighed by that big red brick or cement cinder block or whatever it is. And so when it gets outweighed, it has to not only be outweighed, but it has to be substantially outweighed. So if the probative value is substantially outweighed by the danger of unfair prejudice or any of the other 403 dangers, then it will be inadmissible. Now, notice the term weighed. Sometimes that throws lawyers and students off because they said, wait a second, I thought the jury is the one that weighs the evidence, not the judge, because the judge is not the fact finder, the jury is. Now, if the judge is if it's a bench trial, of course, they would be the fact finder. But it should be for the fact finder to do weighing, not for the judge. Well, in this instance, the judge is weighing the evidence not to make the ultimate determination that the jury will make on the verdict, whether it's guilt or innocence or liability or non-liability or whatever it may be. All that the judge is doing is saying, does the probative value, is it substantially outweighed by the danger of unfair prejudice such that it should be held inadmissible? Okay, so that is a legal decision. So even though you may think that's a jury decision because there's weighing, even though there is the weighing of evidence, this is not the ultimate weighing of trying to determine a verdict. It's just part of an admissibility decision under 403, where it allows the judge to weigh the probative value against the weight of the danger of unfair prejudice or the other 403 dangers. And if in her subjective view it's substantially outweighed, then the judge can make a determination to hold it inadmissible. All right, so oftentimes this is done with photographs or gruesome photographs. You could have an example like this of a victim of, let's say, a physical assault. This person was hit in their left eye and they had bruises of their eye, their socket. They had cuts and abrasions on the left side. And we might say, hey, that is a photograph that we wouldn't want in, because we'd have to say, how do you weigh the probative value of that? And there is some probative value. It shows the intensity of the assault, of the attack. It shows the damages. If the defendant is right-handed and hit the victim with his right hand and she got hit in the left eye, it could tend to prove that, so it would be relevant. And the judge might say, even though this might inflame the passions of the jury, and that's the danger of the unfair prejudice, there's still some probative value here. And even if the danger of unfair prejudice outweighs the probative value, it doesn't substantially outweigh it, and so it will be admissible. Now, this is an example of a child who was burned in a fire by arson, and so they want to show the child and some of the damages, some of the bandages. The child has his pet cat there with him, and so some might argue, well, that is really just trying to engender sympathy for this poor victim, and that the only solace he has is a cat, and maybe that's unfair. Now, others would argue, no, that goes to probative value, it's relevancy, it shows the physical damages, but also psychological damages, and in any event, the judge would have to make a determination. And the judge usually will try to say, what is the legitimate purpose of the photograph? For instance, if it is of a crime scene and there are murder victims there, the legitimate purpose is, well, we have to show the location of the bodies, maybe how the deaths occurred, all of those things. A picture is worth 1,000 words, so therefore there's a lot of efficiency in getting across to the jury what happened, what the crime scene looked like. The illegitimate purpose would be, we're trying to get the jury angry. We're trying to get them emotional. We're trying to inflame them so that they can convict somebody. And so that would be the concern, that there's a danger of unfair prejudice. The judge would just have to make that balancing test. All right, now we're going to skip over character but come back to it. So rules 404, 405, 406, we'll come back to those. Those are character and habit. We're now going to go to policy exclusions under rules 407 to 411. And let's start with the first one, 407, that you cannot use a subsequent remedial measure. The purpose here is that we want to encourage people, principally defendants, right, to fix any dangerous conviction or conditions, or remedy a situation in any way that they need to remedy that situation without their remedying the situation being held against them at trial. So what we want to do is get people to give them a proper incentive and not punish them for the good behavior of trying to remedy a problematic situation. Now, it is relevant, right? Now, in this example of an oil spill, let's say we have an oil spill, there are a lot of damages. After the oil spill, the oil company then makes some changes. Let's say there was an oil spill that took place as there was oil being put into a huge super oil tanker. And the tanker ran into a rock and all of the oil came out of the tanker because it hit a rock, put a hole in the tanker, and the oil came out. Then what the oil company and the oil shipping company did is say, hey, let's have double hulls, meaning there's a hull on the outside, but even if it gets punctured, there's no oil there because there's the inside part where the oil is actually stored. And so if it's double, it's like having a double door. Even if you break the first door, you don't get through to the second door. And that way, if there's a puncture, you won't have an oil spill. Well, if the oil company is being sued, and the oil tanker company is being sued for a fraudulent design, and then they do the subsequent remedial measure of having a double hull, we don't want to use the fact that they now design their ships with double hulls to be used against them. Because what would that be? Subsequent, it occurred after. Remedial, they fixed it. And measure, right? The measure was to redesign the oil tanker or whatever it is. So even though it would be helpful to prove, perhaps, the negligence, there's a policy reason why we don't want to hold this against them. And the idea is that we don't want to provide a disincentive for people to take good measures. Now, some people with torts would tell you that's what a tort is for. Torts are there to punish people and provide the right incentives. And so someone is, if there's a defective condition, they're going to fix that because they don't want to continue to be sued again. So be that as it may, put that to the side. Rule 4.7 is what it is, and you can't use a subsequent remedial measure. Now, there are exceptions to this if you're using it for another purpose. For example, if you want to show that the person owned the area in question. Let's say there's a snowy sidewalk in front of my house, and somebody slips on the ice on the sidewalk, and then afterwards I go and clean the sidewalk off. They couldn't take into account the fact that I cleaned the sidewalk off of the ice, because that would be a subsequent remedial measure, right? But if I were saying I didn't have any control over the sidewalk, or it wasn't up to me to do that, the city should have been the one to remove the ice, and that's my defense, but then I was the one who went and cleaned the ice off, then it could come in for the limited purpose of showing that I had control or ownership of the premises, and they could use it for that purpose. Another one that is a little bit more difficult, and oftentimes it gets litigated, is if something is controverted. Let's say somebody visits my home, and they fall on the stairway, and I go to trial, and afterwards I put up a safety banister and some no-slip surface on the stairway. Okay, but then at trial, I try to argue that the stairway was state-of-the-art, it was perfect condition, there was nothing I could have done to make it more safe. At that point, I've controverted the feasibility of making it more safe, and therefore, since I put that out there, they could come back and go against me and say, well, isn't it true you put the non-slip surface on there and you put a handrail on there? So there was something you could have done to make it more safe, and it wasn't state-of-the-art. Remember, with that exception, you cannot ask the defendant, was there something you could have done to make this more safe? And when they would say no, then they'd say, now you've controverted feasibility. You can't ask that question. It has to be the defendant offering themselves that it was state-of-the-art or very extremely safe. Okay, so that's 407. Now for Rule 408, which is in a civil case, settlement negotiations. This would be an example where you would say, not only is an offer to settle a case, or the fact that I give you $100 and we settle the case, the contract or the actual offer to compromise. So the actual money given, or if we never settle and I just offer you, you cannot use the fact that I made an offer to you. Not only that, you cannot use any statements or conduct surrounding the settlement negotiation. Again, this is in a civil case. Now, Rule 410, which we'll see in a minute, is in criminal cases with plea bargaining. But Rule 408 is for civil cases where you're talking about settlement negotiations. And the policy behind it is that we want to encourage people to settle their cases without it being held against them at trial if they decide not to settle the case. The idea is that people will not be forthcoming with their settlement agreements. They won't be forthcoming and be open for a full and frank discussion during settlement negotiations if they're thinking whatever they say can be held against them. Now again, there are often exceptions. So if you're showing bias, right? This person got paid off by somebody, they settled their case, and now they're coming and testifying for them, that could show possible bias. Or if it's an insurance adjuster that is giving testimony and they've settled with other people or anything like that, if it were to show that, or any kind of obstruction of justice, something like that, then you could use the fact that there was a settlement agreement. Okay, so the idea is that we don't want things that people say during a settlement negotiation to be used against them. Note, however, though, that you cannot use this to cloak otherwise discoverable information. Let's say there's some bad information on me as a defendant, some former convictions I have, and they're probably going to find those and try and use them against me if I testify to attack my character for truthfulness. So I don't want them to be able to use those convictions. And so we get into a settlement negotiation, and during the settlement negotiations, as part of the settlement negotiation, I reveal that I have these former convictions. And then later, if they try to use them against me, I'll say, oh, those are cloaked by Rule 408. That's not how 408 works. If it's otherwise discoverable, then you can get that other information that you might have found through reasonable discovery and investigation. What would be inadmissible is if the only evidence you were trying to use is what I admitted to during the settlement negotiation. Then that cannot be used. Okay, Rule 409. This is for any statement made that is an offer to pay somebody's medical expenses. You can't use that against them. And the idea is the same. We want to encourage people to do this kind of thing, or at least not hold it against them. If some defendant goes to the hospital with a victim and then feels badly about what happened, we don't want that to be held against them if they make an offer to pay medical expenses or similar expenses like that. One thing to compare and contrast Rule 409 and Rule 408, if you want to exclude statements and conduct surrounding the offer, you can do that under 408. However, under 409, if somebody makes a statement that is connected with the offer to pay medical expenses, the statements or conduct surrounding the offer are admissible, unlike Rule 408. So to give you an example between 408 and 409, if somebody slips at your house and you're the defendant, they slip at your house and fall, and you say, oh, I'm so sorry that happened, let's try to work this out, this was my fault, I guess I wasn't paying attention. All of that would be inadmissible if it's part of a 408 settlement negotiation. Let's say the same thing happens, slip and fall, and then the person follows you to the hospital. They call the ambulance. And they'll say, hey, don't worry, I'm going to pay your medical expenses. Geez, this is all my fault. I shouldn't have done this. I wasn't paying attention. All of those statements would be admissible if it's only 409. But if you can categorize it as 408, a settlement negotiation, which is broader, then you'll get broader exclusionary coverage. Okay, Rule 410. That is just like Rule 408, only it's in the criminal context. So 408 is in the settlement negotiation civil context, where Rule 410 is in the criminal plea bargaining context. And the idea is very similar. We want to encourage people to settle their criminal cases by engaging in plea bargaining. So offers to drop charges, to plead to lesser charges, all of that, those offers and counteroffers, and all of the conduct and statements surrounding those plea bargaining negotiation sessions are inadmissible. And the reason that they are inadmissible is because we want to encourage people to settle their criminal cases. And so it's exactly the same as Rule 408, and the exceptions are similar. The exceptions are similar that if you're trying to show something else that would show bias or why a witness might lie. For example, this happens in criminal cases all the time. There are two co-conspirators. One co-conspirator takes a plea deal, but part of the plea deal is that they'll testify against their co-defendant. And so now they testify against them. Well, the co-defendant might say, hey, the reason you're testifying against me is because instead of 20 years for this burglary charge, you got off and you only had to do 1 year. And so it shows why they may be biased or why their testimony may be a little suspect. Okay, Rule 411, no evidence of liability insurance. The idea here is that we don't want people or the jury to know whether there's liability insurance or not. We don't want them to think, well, I'm going to find that damages are higher because there's insurance, or lower because there's not insurance, or maybe there's not liability, but we want to find liability because the defendant won't have to pay anyway. The big insurance company with all the money will have to pay. We don't want it to think, or we don't want for people to think that the insured person may have acted negligently because they figured, oh, I'm insured, I don't have to pay this anyway, or that it was negligent not to have insurance. All of those issues are inadmissible because we want people to obtain insurance and for that not to be held against them. And we don't want people to use the fact that there either is insurance or there is not insurance to affect the jury's outcome or incentives in any way. So all of that is inadmissible. Now, again, if we want to use it to show another purpose, we can. For example, again, that I'm being sued for some defective condition in my yard. There's a big crater out there and I've never fixed it or anything, right? And so I'm going to, I get sued for that, and then I try to say, well, I don't even own the house. I don't own the yard, I'm not responsible for that. But then I get insurance on that area. And so now they could show, oh, well, I'm using the fact that you insured it, not to show that you must have been liable, or not to use it to manipulate the jury to get them to find more damages or anything like that. I'm just using it to show that you said you don't own or control the area. Why would you pay money to have it insured if you don't own or control it? So it's similar to the subsequent remedial measure reason why you may be able to show the subsequent remedial measure, to show agency or control or ownership, and that sort of thing. Okay, 404 character evidence. This is the example of whether, and this is an old case, the Casey Anthony case, but are we going to convict someone not so much based on what they did, right? We'll have evidence of what they did, but one thing we want to show is, are they the kind of person that would commit this crime? And so, if so, we want to use that against them, that they would have a propensity to commit a certain crime. So in a way, is this person, this defendant, a good person that wouldn't do this kind of thing? Or are they very evil? Are they really a very bad person that would do this kind of thing? That's what character evidence is. It's not focusing so much on what they did, but on whether they would likely have done this, or whether it would be unlikely that they would have done this because of the type of person they are, the character that they have, the propensity that they have. So we don't want to convict someone just because they are that kind of person, or just because they have that propensity to, let's say, be violent in an assault or battery case. That is why character evidence, the starting point is that it's not reliable and it's usually inadmissible. There are some big exceptions, and we'll talk about those, but the starting point is this kind of propensity evidence is inadmissible because it's not going to what actually happened. It only goes to what likely would have happened given the type of person that this is. And usually what we want is actual evidence that defendant committed this crime on this specific occasion, this time, on this specific charge for this specific crime. Not that they are the kind of person that would likely do it, so therefore they probably acted in conformity with their propensity to commit this kind of crime. All right, so what does the rule say? The rule under 404A1 says it's excludable. You cannot use this kind of evidence. However, there are exceptions. So under 404A2A, you will exclude this kind of evidence generally, but a criminal defendant can open the door by introducing her own good character, and then the prosecution can come through that door and rebut by putting on bad character evidence of the defendant, but only if the defendant opens the door and decides that they want to put on good character evidence first. So, the prosecutor can never put on bad character evidence first. Now, 404A2B1, another option that a criminal defendant has is to be able to attack the victim's character. So the defendant can open two doors. They can open the door on themselves, their own good character, which can be rebutted by the prosecution, or they can open the door on the victim's bad character. And then after that, the prosecution can come back and put on evidence of the victim's good character. Note that in the prosecution case in chief, they can never be the one to raise character evidence. Generally, we'll see some exceptions there. But under these exceptions, the defendant has to be the one that opens the door in their case in chief. And we know that since the defendant's case in chief is after the prosecution's case in chief, then the prosecution can't be the one to open the door generally in this area. Okay, so this is called the mercy rule, which means that the defendant has to be the one who opens the door on character. Well, 404A2B2, this is where if the defendant opens the door on the victim's bad character, then just by doing that action, he not only opens the door on the victim's good character, where the prosecution can come and put on good character evidence, right? But also, he opens the door on his own character regarding that same trait that he attacked the victim's character, okay? And so what that does is it doesn't allow the defendant to say, I'm not going to open the door on my character, but I am going to attack the victim's character on a certain character trait, and then the prosecution can only bring up good character evidence of the victim. This rule makes it that the prosecution can not only bring up good character evidence of the victim, but also they can bring up bad character evidence of the defendant. And if the defendant says, I never opened the door on myself, the prosecution could say, that's true. You never put on good character evidence of yourself, but by putting on bad character evidence of the victim, you opened the door on yourself on that same character trait. Well, 404A2C, this is an exception. In a homicide case only, this is where the prosecution can be the first to put on character evidence of a victim. But it's only where it's a homicide case, in a criminal case, homicide case, where the defendant puts on non-character evidence of the victim, which says that victim is the first aggressor. Now note that the defendant has not opened the door on his own character. The defendant has not even opened the door on the victim's character, because he's not saying that the victim is a violent person. All the defendant has done is say that the victim is a violent, that the victim was the one who threw the first punch. They were the first aggressor. It's at that point that the prosecutor can then put on good character evidence of the victim. And the thought is that the victim is dead. And so now that their character is being, now that the defendant is putting on evidence that they were the first aggressor, and they're not even there to defend themselves, their character should be allowed to defend themselves. So again, in a homicide case only, even though the defendant hasn't opened the door, the defendant in effect has given the keys to the door to the prosecution in a homicide case where you say the victim was the one who was the first aggressor. The victim was the one who threw the first punch. So that's a homicide case. And a good way to think about that is not that the defendant is opening the door, but the defendant has to give the keys to the door to the prosecution so that they can be the first to open that door, but it's only if they've been given the keys in a homicide case where they put on evidence that the victim was the first aggressor. Okay, that's when character evidence can be used. If it can be used in those criminal case exceptions where we're talking about the character evidence of the criminal defendant or the character evidence of the victim, where the defendant has opened the door, or in a homicide case has given the keys to the prosecution to open the door, now we have to decide, well then how do you prove character? And that's Rule 405, the methods of proof. When character is allowed, either if the defendant opens the door, or the prosecution is rebutting, or the prosecution has been given the keys to the door, how is it done? Rule 405 says, by reputation or opinion only. So no extrinsic evidence of a specific instance of conduct. That's what Rule 405B says. No extrinsic evidence of a specific instance of conduct. Now, we can use extrinsic evidence of reputation or opinion, and the extrinsic evidence would be a character witness who you call up that either gives good character evidence of the defendant or bad character evidence of the victim. If they do that, you can only ask them, what is the defendant's or the victim's reputation in the community? Or in your opinion, since you know the victim or the defendant, are they a violent person? What's their reputation? That sort of thing. So reputation or opinion. No specific instances of conduct, but there are always exceptions. Unless character is an essential element of the charge, claim, or defense. This is something that we're going to see in 405B, where there are rare circumstances where character is an essential element. For instance, if it's a negligent entrustment or a negligent hiring kind of case, you have to be able to show that the person that they hired or that they entrusted to had a bad reputation. And therefore, it becomes an essential element of the claim, charge, or defense, and you have to be able to use that. Another example is parental fitness in a child custody case. You have to be able to bring up the parent's character, because what we want to do is be able to show what kind of person they are. In those instances, those rare instances where character is an essential element, then you not only get to use reputation and opinion evidence, but you can also use a specific instance of conduct. So to give you an example, if we're talking about a person and we're saying the defendant is a peaceful person, all right, the only way we can open the door on that is by bringing up a character witness that says the defendant has a reputation for being peaceful. In my opinion, the defendant is peaceful. You couldn't say, one time somebody pushed the defendant and instead of fighting back, he just said peace to you and walked away. Okay, that would be inadmissible because that would be extrinsic evidence of a specific instance of conduct. It has to go reputation or opinion. However, if character is an essential element of a claim, charge, or defense, for example, in a libel or slander case, if the defense is truth, so if the plaintiff is suing because the defendant said that the plaintiff is a dirty, rotten scoundrel who steals money and is a thief, and so the plaintiff is suing for defamation and slander, and it was written so it's liable too, and the defense is truth, that the plaintiff really is a dirty, rotten scoundrel and is a thief. And so if the defendant is going to prove that truth as a defense, then they have to be able to prove it using reputation, opinion, or specific instances of conduct. So that's when you can use that. Also, another time you can use a specific instance of conduct is on cross-examination. Now, if you want to cross-examine the character witness, you can ask about a specific instance of conduct. If it's a pertinent conduct or a pertinent trait, the judge allows it in her discretion, and there's a good faith basis for asking the question. If so, then you can ask the question, but you are stuck with the answer. There's no outside extrinsic evidence. You're stuck with whatever that witness says. So let's say the witness is called by the defendant. The character witness says that the defendant has a good reputation for peacefulness. In the opinion of the witness, the defendant is very peaceful. On cross-examination, the prosecution could come up and say, well, did you know that the defendant once beat up somebody? All right, you can ask that question if there's a good faith basis for it that you can show to the judge why you're asking that question. You're not just making it up, but there's some evidence to show that the judge allows it in her discretion, and it's a pertinent character trait. And saying that they didn't beat up someone or something, or they did beat up someone would be pertinent to the fact that the character witness said that the person is very peaceful. Now, that character witness, if they say, yes, I heard about that, that is okay, because it's not extrinsic evidence, it's intrinsic. That's what the witness is saying, and it's a way to test their credibility. If that character witness thinks the person is very peaceful, even though they're aware of this incident where he beat up someone, then it shows that their credibility isn't that sound. If they don't know about it, you could sort of imply, well, they don't really know the defendant that well. Here's the thing, though. Whatever that witness says, you're stuck with that answer. You can't bring proof. You can't bring that other individual who got hit by the defendant, because that would be extrinsic evidence. But you can ask about it if the judge allows it. All right, so if a defendant raises the victim's character, he of course opens the door on the victim's good character, because now the prosecution can come back and get him, but he also opens the door on his own character. So I just want you to remember this idea, and don't forget the homicide case exception too, where the defendant opens the door on the victim's character, or really gives the keys to the prosecution to open the door just by putting on evidence that the victim was the first aggressor. 404A3, that's another part of the rule where it says that the witness character for truthfulness can be attacked. We will put that off, and you should go look at Rule 608 and 609, which deals with character for truthfulness. Character for truthfulness of a witness is the only pertinent character trait. All right, so now there's also Rule 404B. This is for non-character, non-propensity evidence. So if that's the case, we know right offhand the special character rules are inapplicable because we're not talking character. So anything under 404B would be admissible, right? Even if the evidence could improperly be used for propensity, if you're trying to use evidence of other prior crimes, wrongs, or acts, just because it could be misused as character, if you can find a non-character reason why this would be circumstantial evidence of something that is legitimate, non-character, and relevant under Rule 404B, then it will be admissible. A good mnemonic to use is Miami Cop. Miami Cop would stand for, each one of those letters stands for the type of thing that you could use for a non-propensity propensity purpose. Remember, usually, if we're talking 405A, we're talking about the method of proof being reputation or opinion only, no specific instances of conduct, unless 405 character is an essential element, then any method is okay. So again, I want to talk about how to determine if the prosecution can cross-examine on a specific instance of conduct to test credibility. If you can demonstrate that there is a good faith basis for the question, and if it is relevant of a pertinent character trait, then you can ask about it. Now, the witness should know about it if it's an opinion, or the community should know about it if it's reputation. Strictly private matters can't be asked about because that would be unfair. They shouldn't know about them. Okay, now 404B, again, when we're dealing with non-character, similar acts admissible to prove any purpose other than character. Remember the mnemonic that I had given you, Miami Cop, and we can think of that like the M for motive. If we're trying to demonstrate that the person, let's say it's an assault of somebody, and we're trying to show that, and we want to use the fact that they've assaulted this person in the past. Now, that would be inadmissible, of course, if we're trying to show propensity, because we shouldn't be able to, the prosecution shouldn't be able to open the door on character and be able to say this person is acting in conformity with their propensity to be violent. Defendant hasn't even opened the door, that wouldn't be allowed. And even if the door had been opened, it would be the wrong method because it's a specific instance of conduct. So it's wrong, wrong, wrong for all of those reasons. However, if the prosecution is saying, I'm not using the fact that the defendant assaulted the victim a year ago, I'm not using it for a propensity purpose. I'm not opening the door on character, I'm not doing any of that. I'm using it for the 404B purpose of showing that there was a motive, that there was bad blood between these two already, and that when defendant attacked this person, they attacked them for a reason because there was existing bad blood. Now you're showing it only to show motive, and the jury would need to be instructed that they could use that prior assault only to show motive, but not to show general propensity, and that this is a bad person who is probably violent. Okay, and it's the same thing for the other examples. Intent or knowledge. We know that this person was purposefully trying to do this, or again, it's the same kind of idea. They had the intent to do this, or accident, or a mistake, or a lack of accident or mistake. Let's say that the defendant broke into a safe of the victim, right? In their office, they had a safe and there was a lot of money in there. And the defendant also picked a lock before that the victim had, and it was a special kind of lock, right? And so this would show that there is no mistake as to what was going on, or this wasn't some accident that occurred. They knew exactly what they were doing. Now again, these things sort of overlap. You could say motive, intent, absence of mistake, identity. If somebody robbed a bank and they had a certain costume to disguise themselves, and it was a clown costume, and then then a defendant robbed a bank in a clown costume, and then we could show that that defendant had robbed a previous bank in a clown costume, we might be able to show that previous bank robbery. Again, not to show that the defendant is a bank robber who has a propensity to rob banks, and so if he did it before, he probably did it again. That would be improper under 404, unless the defendant opened the door on his general good character, and then you could bring up bad character. But even then, it would be improper because that would be a specific instance of conduct, so you couldn't use it. However, the prosecution could say, no, I'm using it for a non-propensity purpose. I'm using it to show we're trying to figure out who robbed the bank this time. And the bank robber had this special clown suit on that they wore as a disguise. We think the defendant did it, and we have some other evidence connecting him to the crime. Some of that evidence connecting him to the crime to show that that was probably him is that he robbed a bank before wearing a clown suit. So that clown suit tends to identify him in this bank robbery. So again, if it's being used for that non-propensity identity purpose, then it would be admissible, and you wouldn't have to open the door or have it be done reputation or opinion, because it doesn't fall under the character rules. Common scheme or plan, same thing, opportunity, modus operandi, that's the MO, that this is how they do this sort of thing. You could use it for those purposes as well. All right, so if you're using it to show any of these other things that are non-character and non-propensity, then you could go ahead and use them. Now, remember, a defendant. The defendant has to open the door first for this to be used against him, any character evidence, or has to give the keys in a homicide case by showing that the victim was the first aggressor. But the defendant should not do this. The defendant should not open the door this way if they have skeletons in their closet. If there's negative character evidence against them, this is the incentive not to open the door. So it's be careful what you ask for. Yes, you're putting on a character witness that is saying good things about you, but that just gives the prosecution the opportunity now to come and put on bad character about the defendant. Okay, some trial timing issues. Remember when we talked about the preliminary matters, motions in limine, those come very first at the trial, even before a jury is impaneled. Then we have the voir dire process where the jury is impaneled. We have challenges for cause or peremptory challenges. We select a jury. We find an unbiased, fair jury. And then the plaintiff or prosecution gives an opening statement. Defendant gives their opening statement. And then we are ready for the presentation of evidence, where the plaintiff or prosecution will put on their case in chief. This preliminary thing, the opening statements, voir dire, selecting the jury, the preliminary matters, the motions in limine, all of that is not considered evidence. There's no evidence, and in particular, there's no evidence of character. So the defendant doesn't open the door, even if the defendant talks about defendant's good character in an opening statement, because technically it's not evidence of character. And to open the door, there has to be evidence of character. Now, some judges will rule that even though this is not evidence, the fact that the defendant has telegraphed it so much that there is good character evidence, some judges will allow the prosecution in their case in chief to bring up the bad character evidence of the defendant because they opened the door during opening. But technically, this is not supposed to be evidence, and technically under the rule, it's not until the defendant puts on evidence of character, and they can't do that until their case in chief. So that's their issue. So in a civil case, we would have the plaintiff's case in chief or the prosecution's case in chief. Now, in a civil case, you cannot use character evidence in any event unless character is an essential element under Rule 405B, like a child custody case. Then all bets are off. You could use reputation, opinion, and specific instances of conduct, and the defendant doesn't need to open the door. The plaintiff can raise that issue right then, at this point in their case in chief, if they're using 405B, right? Criminal or civil case, if character is an essential element, then the prosecution can bring it up. Otherwise, the prosecution cannot open the door. If character is not an essential element, and most of the time it is not, the prosecution cannot use it. A plaintiff cannot use it just because even if a defendant can't even open the door in a civil case. Now, there's a minority jurisdictions which hold that if the underlying action in a civil case is criminal in nature, then you can use character. All right. So, and also if there is a usage on 405, then you can also ask about this on cross-examination. But since it is an essential element, then you can use extrinsic evidence of a specific instance, reputation, or opinion. So the general point is that in a plaintiff's case in chief, because it's civil, you can't use character evidence anyway, unless it's a minority jurisdiction and the civil case is criminal in nature. Or if in a civil or criminal case, character is an essential element under Rule 405B. If so, then you can use it, and the prosecution or the plaintiff doesn't need to wait for the defendant to open any door. Also note that if you have a 404B non-character, non-propensity, other crime, wrong, or act, you could use that at this point in either a criminal or civil case, and that is because it's not character by definition. So none of the character rules apply, so we're not limited to a criminal case where the defendant has to be the one to open the door and it has to be a pertinent character trait. None of that matters because by definition it's 404B, non-character, non-propensity, so we can bring it up in either the prosecution's case in chief or the plaintiff's case in chief. Okay, so that's the plaintiff's case in chief. Now for the defendant's case in chief, in either a criminal or civil case, the defendant can bring it up in a civil case only in a minority jurisdiction where the underlying action is criminal in nature. Otherwise, not even a defendant can open the door in a civil case. However, if there is a 405B essential element, then they of course can bring it up, and they can bring it up in any form, reputation, opinion, or specific instance of conduct. And that's because the plaintiff or the prosecution has already brought it up. Again, if it's 405B essential element. Now, if not, this is where the defendant in a criminal case can open the door on character. 404 A2A, where the defendant can open the door on the defendant's own, what would be good character. Also, in a criminal case, the defendant can open the door on the victim's bad character. But remember, by doing this, under 404A2B2, the defendant also opens the door on defendant's character on that very same trait. Okay, so that's a lot of door opening that can take place in the defendant's case in chief, right, where they get to do the opening of the door. So in their case in chief, remember, either plaintiff or defendant, prosecution or defendant, can raise character evidence in all three forms if we're dealing with 405 character as an essential element. If we're not dealing with that, though, remember, in a criminal case, the defendant can open the door on his own good character or can open the door on the victim's bad character. But if the victim or if the defendant does open the door on the victim's bad character, the defendant opens the door on his own character on that very same trait. At that point, the prosecution, or in a civil case, if it's a minority jurisdiction that's criminal in nature, the plaintiff, but usually it would just be in a criminal case where the defendant has opened the door. Now the plaintiff or the prosecution could come in and ask about specific instances of conduct. right? They can test the credibility of these witnesses. But remember, to ask about these, there has to be a good faith basis for the question. It has to be in the judge's discretion, and it has to be of a pertinent character trait. But you can ask about these. Remember, because of Rule 405B, you are stuck with the answer. No extrinsic evidence of a specific instance of conduct, but you can ask about them. It's just that you're stuck with the answer. Remember that the prosecution can also call their rebuttal witnesses to do the same thing. And now with the rebuttal witnesses, now that the defendant has opened the door on their good character, not only can the prosecution cross-examine them and ask about specific instances of conduct, but the prosecution can also call their own character witnesses, and they can rebut whatever the defendant opened the door on. So if the defendant opened the door on himself, then we can attack his character. Or if the defendant opened the door on the victim's bad character, now the prosecution can put on evidence of the victim's good character. But also remember that if the defendant attacked the character of the victim, then under 404A2B little 2, the prosecution can also attack the character of the defendant on the same trait, even if the defendant didn't call a character witness and open the door on himself by saying that he had good character. The defendant would have opened the door nonetheless by attacking the victim's character, but it would only be open on the defendant to the extent that the defendant attacked a character trait of the victim. All right, so those issues, if you think about it, those rebuttal witnesses are really going against what the defense witnesses said. So the prosecution could call witnesses now that say the exact opposite of what the defense character witnesses would have said. Now, if the prosecution calls those witnesses, of course the defendant gets to cross-examine them, and part of cross-examining them would be able to ask about specific instances of conduct. But remember, you also, as the defendant, would be stuck with whatever answer they gave because there's no extrinsic evidence allowed. And remember, if they do ask a question about a specific instance of conduct, there has to be a good faith basis for it, it has to be in the judge's discretion, and it has to be of a pertinent character trait. But they get to ask those questions just the way the prosecution could test the credibility of the character witnesses of the defendant. Now the defendant gets to ask about specific instances of conduct to test the credibility of the character witnesses of the prosecution. Okay, Rule 406, and this goes along with habit in a sense because it's the next rule, but it's important to draw the distinction between 404 character propensity, which is inadmissible, and Rule 406 habit evidence, which is admissible. If we create a spectrum of character versus habit and try to categorize these, things that are more general will be character, things that are more specific would be habit, things that involve more of a thoughtful volition are character, unthinking, automatic things are habit, broad versus a narrow disposition, many manifestations versus one manifestation. All right, a good example of this would be take someone who turns a left turn signal every time they come to a stop versus someone who we say is a careful driver. If we try to say someone is a careful driver, that is going to be more on the character side because it's more general, right? Whereas if we say they always use their left turn hand signal whenever they come to a stop sign, That's more specific. It doesn't have all kinds of possibilities, but it's a very specific driving habit as opposed to the very general character, this person is a careful driver. There's more that goes into the thought of being a careful driver, many more decisions. Do I turn left? Do I stop at the light? Do I not speed? All of those things involve thoughtful volition, where you can think of a habit more as unthinking, automatic, almost like breathing, like your heartbeat going. You're not really deciding for that. It's just how you react to a specific set of circumstances. It's automatic versus you have to think, well, I'm a violent person. Am I going to get in a fight this time because I'm that way? It's, you wouldn't say someone is in the habit of being violent because that would be more of general character. Broad versus narrow disposition. Look at careful driver versus always using your left turn hand signal, and many manifestations versus one manifestation. So conceptually now, habit violates the propensity rule, but it's not character, because we're talking about a certain propensity. It's just your habit propensity is more reliable. It's confusing to some people to think about it because we usually use the word propensity for character only. So I'm reluctant to do that. But also you should conceptually be aware that we're saying if somebody has a habit of making the left turn hand signal, then we're going to assume that they probably did it this time in conformity with their habit. So it has a propensity element to it, but it's much more narrow, much more specific, and much less thought goes into it. If you think about it, character might be thought of as a huge aggregation of a bunch of habits of the person. Now, character is much more than that, but that's at least a helpful way of thinking about the categorical relationship between character and habit. If character is generally inadmissible, even though there are those criminal exceptions, why is habit generally admissible, even though there's still propensity or a likelihood that something was done rather than not done? And again, it's because it is a little bit more reliable, right? Someone commits a bank robbery, D alleged to have robbed while being barefoot or no shoes. Defendant was charged 3 times last year with stealing and jaywalking while barefoot. Is this relevant, admissible habit evidence or inadmissible, improper character evidence? Well, it really depends what you're trying to show. Are you showing that they had a certain character trait and they're acting in conformity with that general trait, or that they have a habit of being barefoot? Now, if it's only 3 times in 1 year, that may not be enough repeated instances. And barefoot, it is a little bit more narrow than just doing some general kinds of things. So my point here is that it's along a spectrum where you can make arguments that it's habit or make arguments more that it is general character. Sometimes Rule 404B can help you with this, because maybe you could say, well, it's not really a habit because it wasn't done enough times, but it's still more specific than a general, like being a careful driver. But maybe I could get these 3 barefooted bank robberies and jaywalking barefoot to show identity, to show that the person this time was barefoot, and this person also on many other instances is barefoot, and maybe I can show one of the eyes in Miami Cop to show identity or modus operandi. This is how this person does it. So it might be able to help in that regard. And remember, we're not going on the propensity spectrum anyway, because we're saying it's non-propensity. Okay, I'm going to take a break and be back in about 5 minutes so we can edit this part out, and we'll start with Rule 412, sexual assault. All right, continuing with Rule 412, character in sexual assault cases. And generally you could look at the criminal law character opening the door exceptions for character as inverted when it comes to the victim and the defendant in sexual assault cases. Rule 412A, first of all, states that a victim's past sexual behavior or predisposition is inadmissible in a civil or criminal case. And so, of course, in a rape case, that is the worst of a sexual assault, but it doesn't necessarily have to be rape to be a sexual assault. So any criminal or civil sexual assault case, if it's qualified that way, then the usual ability for the defendant to attack the character of the victim is no longer possible. The defendant does not get to open the door on them. All right, so the victim's past sexual behavior or predisposition is inadmissible, so there's no reputation or opinion evidence of the victim in a sexual assault case or specific instances of past sexual conduct. Now, that's the starting point. There are criminal exceptions. So in a criminal case, when a defendant is charged with sexual assault, there are certain times, they're rare, but there are times when a criminal defendant can bring up specific instances of sexual behavior or sexual predisposition by the sexual assault victim. And so under 412B1, there are three of them, A, B, and C. 412B1A says if you're trying to prove that the defendant is not the source of the semen or injury, this would be where a criminal defendant says, okay, I'm defending against evidence that the prosecution has put on that, let's say, the sexual assault victim has sexual injuries, injuries to her genitalia, and the defendant can say she was with other sexual partners 6 hours before she was with the defendant, and therefore those injuries might be a result of those other individuals, not just the defendant. So strategically, it is a mistake for the prosecution to use injuries that way if they don't want these other sexual partners to be admissible, because the defendant will be able to use them in those instances. 412B1B would be if the defendant is trying to prove that the victim had consensual sex with the defendant in the past, on past occasions. So in that instance, if the defense of the defendant is consent for this particular alleged sexual assault, then the defendant can bring up the context of their prior sexual history with one another to try to show that the defendant may have thought that this was consent. This is often criticized as a boyfriend or former husband defense, where it shouldn't be that the boyfriend or former husband gets to sexually assault a sexual assault victim because of their past relationship. Just because they said yes in the past doesn't mean yes forever. Although the idea is that it's not to say that it's not a sexual assault or a rape, it's just relevant and admissible to the issue of consent to give the context of the prior relationship. But that certainly doesn't excuse what could otherwise be a completely improper, illegitimate sexual assault by a former boyfriend or husband. Again, this is only with the defendant. So no other sexual history or predisposition or behavior with people other than the defendant. It's only the defendant. Now, a larger catch-all one would be 412B1C, which would say if there are circumstances where it would be constitutionally required in order to have a fair trial or to allow due process, then it's allowed. This is kind of like a constitutional fail-safe or safety valve where it's not unconstitutional, at least on its face, and people can confront witnesses against them if that is required. And so the judge has the ability in those instances to not require an unconstitutional suppression of evidence. But often those circumstances are very, very rare where a judge will find that something is constitutionally required. There are various timing and notification requirements to make sure that the victim is not victimized again. So a lot of this has to be done under seal. The information, you have to give information that there is an intent to use this so that the prosecution could come and fight it. Then, with respect to Rules 413 to 415, if Rule 412 inverts the idea that a criminal defendant can attack the victim's character, Rule 413 to Rule 415 inverts the idea that only the defendant can open the door on his own good character, and then once opened, the prosecution can come through that door and put on bad character evidence of the defendant. In a sexual assault case, that's inverted, where the prosecution can bring up past sexual crimes or acts of defendants and use those against the defendant. And the defendant can't say, well, I didn't open the door. And the reason is this is a sexual assault case. And the idea here is that we're making sure that sexual assault victims don't feel victimized again when they report a sexual assault. The problem is not false reporting, the problem is underreporting. And so these laws from 412 to 415 were ways to try to incentivize reporting and make sure that victims are not victimized twice and accused of lying, essentially, by putting up their whole sexual history. Also, there's a distinction, too, that consensual sex is very different from non-consensual sex. That one is a crime of violence, one is just not a crime, it's a consensual activity. And so it's unfair to try to taint the victim with this activity when consensual sex is very different than non-consensual violence. Okay. This is often given as an example. Let's say a prostitute is raped. Is the fact that she a prostitute relevant? Now, it used to be, before we had these rules, that some judges would find that that is relevant, that maybe it was consensual, that maybe the defendant didn't mean for it to be a sexual assault. But even if it's relevant, it could be excluded, or sometimes they would try to argue that it should be excluded under 403 as unfair prejudice, because there's really not a lot of probative value there, but there is a lot of danger of unfair prejudice where a provincial jury might say, well, that's what she gets for engaging in that kind of activity, which is completely wrong and unfair. So instead of relying on Rule 401 that it's irrelevant, or even 403, even if it has some probative value, it's unfairly prejudicial. Many quote-unquote good judges or fair judges would knock the sexual predisposition or sexual history of the sexual assault victim, they would find it irrelevant or unfairly prejudicial. But those rules weren't enough, because although the good judges were using them, there were many judges that were not using those rules and that were allowing that to come in, and that's why we needed Rule 412 to make sure that the defendant or the sexual assault victim gets protected that way. Again, the idea would be, if an accused rapist raped a woman a year earlier, is that relevant? Yes, that would be relevant. Maybe that's 403 prejudicial, but sometimes what a criminal defendant would be able to say is, I'm not opening the door on my character, and since I'm not opening the door on my character, you can't use this against me. And even if you did, if you tried to use it as character, and I haven't opened the door, it's a specific instance of conduct, therefore inadmissible. And often this would be inadmissible. Rule 413 through 15 makes this kind of thing admissible now. It's an admissible specific instance of conduct, and it can be used not only for a 404B purpose, right? To say a Miami cop non-propensity, but it can also be used for a propensity purpose, to say that the defendant is a bad guy and has a propensity to engage in sexual assault, and therefore, jury, you can take that into account and decide if the defendant probably acted in conformity with the propensity to engage in sexual assault. Okay, now moving to Rule 500 and privileges. This is the protection of certain relationships and confidential communications. The chief ones are attorney-client and the spousal and the marital communications privileges. Doctor-patient is one that is often used. The main one, though, is the attorney-client, and the idea is that we want to maintain the confidentiality of the communications between these two so that the relationship can work. Remember, you have to have a client. Even a corporation under the Upjohn case can be a client. And then there's the attorney. It could be the attorney or somebody representing the attorney, so an investigator, a paralegal, anyone like that. Anyone that the client gives information to so that the attorney can give them legal advice, that would be protected. There has to be a communication where the client actually is communicating something to the attorney. If it's just an observable fact, then that may not be a communication. It also has to be something where there has to be a lawyer-client relationship. It can't be that they're just a friend. Also, it has to be in anticipation of specific litigation, and you're trying to get the information for that specific litigation. And then finally, it has to be in the context of that relationship, and it can't be waived. Meaning, if you publish it, if the attorney doesn't want to hold this information, or if the client doesn't hold this information confidential, then it is considered waived. It's so if there's a third party present, or other people can hear you because you're broadcasting it, then the system isn't going to respect the attorney-client relationship because the client is not respecting the attorney-client relationship in terms of the confidentiality. So you look at the totality of the circumstances, you look at the reasonable expectation of privacy and confidence with the attorney-client relationship. With respect to the spousal privilege, remember, if there are spouses, they have to be married. It could be, now that the law has come down, that it could be gay marriage. So wherever the gay marriage is recognized, then If it's a marriage, it's a marriage, and so you get the privilege. The spousal privilege you can think of like the Fifth Amendment right against self-incrimination. And to the extent a marriage is a unit, the unit doesn't have to testify against one another. So what that means is if a testifying spouse does not want to testify, they don't have to. Now, if they do want to testify, they can. The relationship's probably not very good anyway if they want to testify against one another, so they can do that. So the non-testifying spouse cannot use the spousal privilege. The spousal privilege is for the purported testifying spouse that does not want to testify against their spouse. But if you do want to testify against your spouse, you can. Just like the Fifth Amendment right against self-incrimination. If you waive it, if you want to testify against yourself, you can. So half of you can't say, hey, the other half of me doesn't get to testify against myself. I can testify against myself if I want to. It's the same thing with members in a marriage. The spouse gets to testify against you. Now, if the parties divorce, then there's no more spousal relationship. So if they're divorced, now if the ex-spouse does not want to testify, too bad. They have to testify. There's no spousal, privilege against not having to testify against your former spouse. That's the spousal relationship. The confidential marital communication privilege is much more like the attorney-client privilege. It's much more like it in this sense. What we're trying to do is protect confidential communications. So if one spouse tells the other spouse something in the context of their marriage that's intended to be confidential, and there's no publication of that, then we will give it the same protection we give the attorney-client privilege. And like the attorney-client privilege, it survives. So if the parties get divorced, what they said to one another in confidence is still protected. Just like the attorney-client privilege. Even if the attorney fires, the client fires the attorney and the attorney-client relationship ends, the client still is entitled to the privilege where the attorney cannot testify against them because it survives the relationship, just like it does with the marriage. It survives a divorce. Okay, but if it's published, if it's said not in the context of a confidential communication, but someone else was present there, then it is waived, and like the attorney-client privilege, the confidential marital communication privilege will not be there for it. Okay, doctor-patient is just another one of these, and really the point there is that Rule 501 talks about privileges that are a matter of state law. So in diversity cases, you apply state law privileges because they are considered substantive law. Only in federal question cases in federal court do you use case law that is federal, kind of like the federal common law case law for these privileges. But otherwise, in diversity cases, you go to the state law on privilege. Again, the policy reason behind this is that we are protecting relationships, and we protect these relationships even if it means that we give up a little bit on searching for the truth. So it's probably true that an attorney has very good relevant information against a client, or a spouse has very good information against a spouse. But even though that's relevant and helpful information, we still protect the sanctity of those relationships and say the search for the truth and uncovering the truth is not worth getting rid of these relationships or having it where people cannot depend on the confidentiality in these relationships. So we're going to search for the truth, but not at all costs. And you may say, isn't this costly? because we're giving up some justice. But sometimes you have to do that to make these relationships work. And so that's the policy reason behind it. Okay, now to the 600 rules, which involve witnesses. Extremely important article, because overall it deals with how attorneys are allowed to question and cross-examine witnesses in general, and all the various techniques that are used and allowed and not allowed when we're talking about witnesses and their credibility. So let's start with Rule 601. And the basic rule is a qualification rule. Witnesses need to be qualified or competent to testify in court. Now, having said that, the rule is extremely low to qualify to be a witness. All you have to do is basically, and I mean very basically, be able to communicate, be able to understand the difference between right or wrong, the consequences of perjury, the ability to communicate, even if it's very rudimentary, the ability to remember something. It's not, your memory is foggy, but you have no memory whatsoever. So the qualifications are very, very low. We deal with the lack of qualifications through cross-examination. But gone are the days when people like atheists couldn't be qualified, members of your family because they're biased, any of those kind of things, or where, it used to be that children couldn't testify, women couldn't testify, non-property taxpayers couldn't testify. There are different rules like that. Now, everyone can testify, even someone that has a drug problem or something like that. All those issues are dealt with under cross-examination and with credibility. Those all go to credibility, those all go to weight, not to admissibility. So the law is very, or the standard is very low. Now, this focus, usually with evidence, we're focusing on the testimony that a witness is giving. This particular rule goes to, can that witness even take the stand? So usually it's if a witness is taking the stand, and then rules of evidence deal with what they are being asked and what they are saying. But the even more rudimentary rule is, can that witness even take the stand? Are they even qualified? So we're not talking about admissibility of what the witness is saying. With Rule 601, we're saying, can that witness even take the stand? And that's what competency is. Are you qualified? So whether the witness should be believed, whether their credibility is good, that's not the issue. It's not whether somebody is not credible. It's just whether they are competent. So the standard is very low under Rule 601. We leave much of this to cross-examination. And so the testimonial capacities simply have to exist. Some people say it's so low, are you breathing and can you communicate? If so, you're competent to testify. Now, you have to have some memory. The only way you'll be incompetent is if you have absolutely no memory at all. If your memory is foggy, well, then that's something for cross-examination. If you have no perception at all, then you're not competent. But if you couldn't see that well, or you were kind of far away, all that goes to just general competency, right? So you can be cross-examined on that. So it would have to be where you have no memory at all. But if your memory is foggy, you're competent to testify. Now, if you don't have personal knowledge, and that comes into it too, because Rule 602 requires personal knowledge of the witness. In order to be a witness, you had to have witnessed something. That's why you are called a witness. So that is a requirement, that you're competent and that you have some personal knowledge that you can share. Now again, this is not difficulty in communicating. That's just something you can be cross-examined on. It would have to be For you to not be competent, it would have to be that you have no ability at all to communicate, and therefore you can't be examined, or you have no memory at all of anything relevant that happened, and therefore you can't be cross-examined at all. Okay, under Rule 604, we need to have interpreters give an oath. And what their oath, it's a little bit different than the oath of the person who is giving the testimony. That person has to give testimony as to what they witnessed. An interpreter is not a witness because they didn't witness anything pertinent to the case, but they are, in a sense, a witness who is witnessing what someone is saying in a different language, and they're promising just to translate it into the language of the court so that the witness and the court can understand what they're saying. Their oath is just that they're going to interpret in a fair way. Rule 603, you have to give an oath or affirmation. It doesn't have to be "so help me God." It doesn't even have to mention God. But what it does have to do is awaken the conscience. Let the person know that it's very important that they tell the truth and that there are consequences for not telling the truth. It's very important, and they could also be subject to perjury. There's no specific oath, although some of them are pretty typical, because most of the time it serves the function of awakening the conscience and letting the person know that if they commit perjury, they could be there are consequences to that. And also, just that they understand that it's very important to tell the truth. With Rule 603 and giving the oath, do not confuse that with Rule 610, where Rule 610 is about no religious beliefs to either boost or harm credibility. It used to be that if somebody was not a good Christian, you could bring that up against them to show that they're probably going to lie, or they don't understand that they are breaking one of the 10 Commandments, they can go to hell for lying, that sort of thing. Now, we can't use that. Religious beliefs aren't supposed to be used to either help or hurt. But of course there are exceptions. If you're trying to show that, for instance, someone had an alibi, and their alibi is that they were at church, but then you want to attack their alibi because you say, well, you're an atheist, so what would you be doing at church? That's okay, because you're not saying you're an atheist and therefore you're a liar, or you're an atheist and therefore you don't believe you'll go to hell if you lie, because that would be improper under 610. But it's proper under 610 to say, hey, I'm attacking your credibility because you're trying to say you weren't at the sign of the cream or at the crime because you were at church, but you're an atheist, so you wouldn't be at church. Now, they could have an answer for that. They could be, they were just interested, or they were exploring why people believe when they shouldn't believe, or whatever. But at least they'll have to answer, or at least the fact that they're an atheist is admissible because it's only going to the purpose of attacking the credibility of their statement that they were at church as their alibi. Okay. Now, for the witness on the stand. Often what we're doing, what the rule deals with when we get to rules 607, 608, 609, we're going after the credibility of the witness, and we're wanting to impeach them. Before we do that, though, just a couple of things about judges and jurors. And lawyers. Under 605, judges and jurors cannot serve as witnesses. Now, judges can ask a question, they can also comment on the evidence, but if they are an actual witness, they have to recuse themselves. An attorney cannot serve as a witness, they'll have to recuse themselves. Under Rule 606, a juror cannot impeach a witness or impeach a jury verdict or indictment. They cannot be called, therefore, as a witness, a juror. because they can't serve as a witness in the case currently that they're on, or also they can't be called as a witness to attack a verdict of which they were a part of, unless the influence on them was an external force. So anyway, with impeachment, this is the process of calling into question the witness's credibility. Rule 607 allows you to impeach any witness, even your own witness. It used to be that you couldn't impeach a witness that you called because you were vouching for that witness. But now that that is allowed, you can impeach your own witness. You just have to clear with the judge permission to treat the witness as hostile in order to allow me to impeach them, and the judge will allow you to do that. Okay, I'm going to take a quick break here. We'll just edit this out and back in 5 minutes. All right, let's talk about cross-examination under Rule 607 and the 600 rules in order to attack the credibility of a witness. First, you want to attack, or at least address, 4 testimonial capacities of a witness. Now, on direct examination, you're trying to build these up and make these look good. But on cross-examination, you're trying to attack these, and these are the methods, or these are the general 4 areas that you'll attack. First is perception. How well did the witness see, hear, or perceive the event? On direct examination, you want to show that they perceived it, they had personal knowledge, the reason why they're a witness, and talk about the perception being good. But on cross-examination, you want to try and attack that, perhaps. Maybe they couldn't see or hear it all that well, or they were far away, or there was obstructions in front of their view, whatever the case might be. Notice how we are not attacking their truthfulness yet, okay? This is just, they could be a truth teller, but they just didn't see it all that well. The second one is their memory. Of course, they have to remember or recall what happened. So how well did they see it? How reasonable is it that they could remember? How long ago was it? You would bring those kind of issues up. On direct, of course, you're trying to show how they have a very specific memory, a very good memory, why this may have been burned into their memory and they'll never forget it, or they'll never forget that view. Again, on direct, you're building it up. Cross-examination, you're tearing it down. Communication in general. Sometimes this is like clarity or narration or whatever it is, but it's getting at the idea of how good of a witness is the witness. How well do they relate? How well do they explain? Does their story make sense? Does the thing they're talking about, the way in which they're talking about it, make sense? Do they seem to make sense? Is the story logical, plausible, possible? Is it contradicted by science? Is it contradicted by anything else? So that's a huge area, and again, both the direct, you want to build it up, the cross-examination, you try to tear it down. Sincerity and bias. Now that's something on direct, you don't really build that up. You just, by putting them on the stand and trying to show they have good demeanor evidence, you want them to seem credible. But on cross-examination, this is an area where you would really try to challenge them. And you might try to either catch them in a lie, or show that they have a reason to lie, or show that they may have an inconsistency in what they're saying. So, is the witness statements, are they being inconsistent? We know that Rule 613 deals with that issue. But is the witness a liar? Do they have bad character for truthfulness? That would be more Rule 608 and 609, which deal with the character of the witness. Does the witness have a propensity to lie, as opposed to have we caught them in a lie, or have we caught them in a mistake? 1, 2, and 3, perception, memory, and communication, are more about catching the witness in a mistake. But number 4 is more about either catching them in a lie, right, the inconsistency, showing that they have a reason to lie or an incentive to lie in this case, which would be they're biased, or showing that they have the status of a liar or a character of a liar, that their character for truthfulness is bad, that they have a propensity to lie and they're probably acting in conformity with their propensity to lie. Those are all very different, and so we'll go through and we'll see how that's done. Before we do that, though, remember what a direct and cross-examination look like and what we're doing here. So under the rule, this is essentially 611 A, B, and C. But in a criminal case, the prosecution, let's say if they're going to do their direct exam, usually in doing a direct exam, they're calling a non-hostile, friendly witness, a police officer, an investigator, a witness for the prosecution, someone on their side. They're not calling the defendant yet, because that would be an adverse witness or a non-friendly witness or a defense witness or anyone like that. So on their direct exam of that non-friendly witness, they get to ask who, what, when, where, why, how, very open-ended questions. They're not leading questions. They're open. They don't suggest the answer. You want to build up the credibility of the witness by giving them a chance to tell their story. And the way you give them a chance to tell their story is to ask these kind of very open-ended who, what, when, where, why, how type of questions. Now notice the defense, when it's their turn to ask that prosecution witness questions, they get to cross-examine them. And see how the arrow is? For a direct examination, it's sort of like you're questioning someone on your side. That's why it's direct. They're non-hostile, they're non-friendly, and therefore you're doing a direct exam where you're asking them open-ended questions. But the defense, the opposing side, cross-examines them because they're on your side, not their side. And so that's why it's called a cross-exam. And the status of the witness changes from the perspective of the defense. The defense is now asking questions of a hostile or adverse witness or a witness associated with the opposing side. And because they're doing that, they now get to interrogate them, in a sense, a little bit more, right? They now get to ask the leading questions. If it's a hostile or adverse witness, then under 611C, you get to ask them questions where you suggest the answer and you sort of tell the story from your point of view in the question, and then the question asks for a yes or no response, which you suggest, and then you get the response you're looking for. And if you don't, then you show how the other side is lying, and then you try to force them to answer the question the way you want them to by showing you've caught them in a mistake or a lie, which we'll get into. Remember, after the cross-examination is the redirect exam, sometimes called the rehabilitation, and then after the rehabilitation or redirect exam is a recross exam. And then after that, we're done with that witness. Now note, under 611B, the cross-examination is limited to the subject matter of the direct examination. So if a witness is called by the prosecution on direct and they talk about the accident that took place at the intersection, the cross-examination has to deal with the accident that took place at the intersection. They can't go into other areas. They can't say how these people got into a fight 3 hours later in a bar because they were arguing about the accident, because that's not what the direct examination was about. So it has to be limited. Now, you can ask the judge, can I go outside the scope of the direct and cross-examine this witness? And the judge, in her discretion, may allow that, but only in situations where, let's say, that witness would not otherwise be available at trial, so that you couldn't call them during your case in chief. And so you're asking permission, hey, while we have this witness here, and while they're in town, can I ask them these questions, some of which are within the scope, but some of which are outside the scope? Because if not, Judge, then we're going to have to re-subpoena and have this witness fly back into town when I ask them the questions. And often the judge, to accommodate a witness, will say, let's just get it done with. And so they'll let them ask the question there. So that's the American rule or the guideline, that it's only within the scope of the direct, that you can't ask questions that go beyond the scope of the direct unless you ask the judge to not apply that American rule, but to let you ask questions, whatever questions you have of that witness that may not necessarily fit within the scope of the direct examination. What is that scope of the direct examination? That's an interpretation call to be made by the judge, but it's whatever the subject matter was. Now remember, credibility is always within the scope. So if you show a bias, or someone has bad character, or a former conviction that comes in to attack their character for truthfulness, all of that is fair game and is within the scope of the direct examination, because just by taking the stand, they're putting credibility in issue. Now, note that it's possible for a plaintiff or a prosecution to do a direct exam, but they may call a hostile or adverse witness. In family law cases, this will happen often where, let's say, the plaintiff for the husband is doing a direct examination, but they call the wife, who is the adverse party, but they want to do a direct exam because they want to get out evidence from the wife. They may think it's even more credible coming out from the wife. Okay, so they can do a direct exam, and even though it's a direct exam, notice that you don't get to ask open-ended questions, or you do, but you shouldn't. You can ask leading questions of this person. Now, you may not want to, but strategically, you might as well do that because you get to tell your story and suggest the answers. So often it's like an interrogation. And this is just to point out that even though it's a direct exam, you can ask leading questions in this example. Now, and you usually can't do that on a direct exam unless it's of an undisputed issue, or you have a forgetful witness, or you need to develop the testimony. Then you can ask the leading question, but you take the credibility hit on that on a direct exam. Otherwise, if you're not asking an undisputed area or just some background area, or you're dealing with a child witness or an infirm witness, something like that, then you can't ask a leading question on direct. But if you have a hostile or adverse witness, then it's like what would otherwise be a cross-exam because it's hostile, but since you're calling them, it's still a direct. And notice the defense, they would be doing a cross-exam just like you would be doing a direct, and I put those in quotes because even though it's a cross-exam and a direct exam, it's sort of inverted. Now the defense, since it's of a non-hostile friendly witness from their point of view, they would say, all right, we have to ask them open-ended who, what, when, where, why, and how questions, because even though it's a cross-exam, it's of a non-hostile friendly witness. Okay, so let's think a little bit more about the way in which we impeach. You go after the competency factors, and we already dealt with those. Perception, recall, memory, communication, narration, your ability to make sense of plausible stories. Those are certainly areas to go after. Now notice, we're not going after their sincerity or truthfulness or being a liar or lying. We're just going after whether they might be mistaken, maybe a good faith mistake even. Now, this other area, veracity, that's a competency area, but that's a huge area of cross-examination. So this veracity, sincerity, it's going to include a lot more. For instance, it's going to include character for truthfulness. Now, character for truthfulness is the idea under 608 and 609 that not that we've caught you in a lie, but we're establishing whether you or not you are a liar. Do you have the status of being a liar? Do you have a propensity to lie? And the way in which we will prove that is through reputation or opinion under Rule 608, because we're trying to say the witness is a liar, So jury, you should be aware that they have the status of a liar, they have a propensity to lie, and so they're likely lying right now on the stand. That's different than saying they couldn't see, their memory is no good, their story doesn't make sense, I've caught them in an inconsistency, or I've caught them in a lie. Because that's a very specific. This is more general. They have the character of a liar. If you're going to do that, you have to call another witness up and say that that first witness has the reputation for being a liar, or in the second witness's opinion, that first witness is a liar. Now, you have to do it through opinion or reputation. You cannot do it through specific instances of conduct. So any specific instance of conduct, hey, I'm going to show that this guy is a liar because he lied on his driver's license application. No extrinsic evidence of that. That's a specific instance of conduct. The one time that the specific instance of conduct is allowed, where there's extrinsic evidence of it, is if it's a former conviction, and then you have to go into Rule 609 and see if that former conviction qualifies. Remember, that former conviction is not being used for a 404 general character, that he's a robber, a liar, he's violent, any of those things. That would be improper. What we're doing is the character of a witness. The only pertinent character trait of a witness is truthfulness. And we can use reputation or opinion as to their truthfulness, or a specific instance of conduct, but no extrinsic evidence of a specific instance of conduct unless it's a former conviction. Then we could use extrinsic evidence of the former conviction if we satisfy Rule 609, but that former conviction only goes to their character for truthfulness, not to their general character. All right, so the competency factors are an area. Veracity involves character for truthfulness, which is the Rule 608 and 609. Remember, there are inconsistencies, which I have this as a third area, but it kind of could go under either communication or veracity, when you're trying to show inconsistencies, to show that you've caught them in a lie or a serious mistake. That's very different from saying they have a propensity to lie as a liar, so they're probably lying now. You're saying, no, I've caught you in a specific inconsistency, which shows that I've caught you in a lie, and that goes after your veracity. So Rule 613 allows you to go after someone to impeach them with a prior inconsistent statement. So if I say in a letter that I attended the February 19th meeting, and then in court today I try to say I never attended the February 19th meeting, the other side cross-examining me could use the piece of paper where in the letter I said I attended the meeting, and they could use that to impeach me, to say, hey, in this letter you said you attended the meeting, and today you said you did not attend the meeting. These things are inconsistent. Jury, you should know that they're inconsistent, because maybe that shows that I caught them in a lie, their veracity is not good, or maybe I've contradicted them and their story doesn't make sense. Now, we'll get into the hearsay, but I just wanted to raise that now. With 801D1A, you also could use it as a prior inconsistent statement, and you could use it for its truth. So go back to the letter that I used, or that the person used to impeach me. I said in the letter I attended the February 19th memo. Today I said I did not attend the February 19th memo. Under 613, they could show the inconsistency with what I said in the letter and what I said today. We're not trying to prove the truth of the letter, but just to let the jury know that there's an inconsistency. If somebody says, well, this letter contains hearsay, it's the hearsay of me, the witness, who as a declarant out of court said a prior hearsay statement, and now you're trying to use this hearsay against me. And that would be a good objection, but the person could say, no, I'm only using it for 613 to show that you give inconsistent stories. I'm not trying to prove this truth of this, that you actually went to the February 19th memo. Maybe I'll prove that another way, but I can't prove it with this. I can only use this to show that I caught you in a lie, and that the jury should think that, hey, this person is not trustworthy because they've lied on the stand. However, let's say instead of this being in a letter, I said in a deposition or in a former trial or in a grand jury indictment that I went to the February 19th memo. Now today in court, I said I never went. Under 801 D1A, this would qualify because I said this one under oath, right? Deposition or at a trial or hearing. And because I said it under oath and it was at a trial, hearing, deposition, or other proceeding like a grand jury indictment, it can now come in not only to impeach, to show that I say different things at different times, but also to show that this is actually true. I can use it for the truth of the matter asserted in the deposition or the trial where I said I went to the February 14th memo, or I went to the February 19th meeting. And so we could use it to impeach and for the truth. Now, what if I don't make a prior inconsistent statement like this, but I get impeached through contradiction, which would kind of go to my communication? Let's say that I said that it was raining the night of the accident, and they actually have weather reports which show that it was clear and dry the night of the accident. So it's not my prior inconsistent statement, but it's still a contradictory statement from the weather report, which calls my story into question, and so it would attack my communication. Now, you can also say someone's perception or their memory is so bad that they are lying. So you could turn their lack of memory or lack of perception into something so ridiculous that you say that we're lying and we're trying to attack you for a lie or that kind of inconsistency. Or you might just say, no, you're not lying, you're just mistaken. So it's a question of, you said that it was raining, but the facts prove it actually wasn't. Here's the weather report. So you were either merely mistaken, and therefore your perception or your memory isn't that good, your story doesn't really make sense, or you're lying and we just caught you in a lie, and you didn't know that we would check the actual weather report, and so now we just caught you lying because you knew it was raining, but you said that it wasn't. So that's a way of going after them. Now, another way to get at the veracity is to go after the bias. Now, bias is not character for truthfulness. Character for truthfulness is you have the status of a liar. You lie in all situations. You have a propensity to lie, and the jury needs to know about that. That's different from saying you have a specific incentive to lie in this case and maybe this case only. All right, your son or family member, their freedom is at stake. There's a lot of money at stake involved in this lawsuit, and therefore you have a reason to lie. You don't want to see this big company you have a lot of stock in get sued and then you lose money. So that would be the bias, right? My son is involved, I have an interest, I'm invested in this, or maybe you even received a bribe and there's corruption there. And so they want to point out that bias or lack of sincerity. Okay, those are all the areas of cross-examination. What are we trying to do with these rules? That is, if there's the witness there and we're attacking their credibility from Rule 607 to 613, what are we going after? We're going after their perception, we're going after their memory, we're going after their clarity or their communication, or how plausible is their story, and then finally the sincerity, the bias. Are they specifically lying, or have we caught them in a lie? All right, now, in these areas where you go after perception, memory, clarity, sincerity, bias, where it's specific, where I'm just trying to say you're a liar, This is admissible information, and this is why you cross-examine. So we're not, or if the witness is mistaken or lying, they're not telling the truth, it's perfectly fine to point this out and use extrinsic evidence. In fact, this is what you would do. You would point this out, and you would point it out using extrinsic evidence. Now, there's an overlap with credibility, which is what we just talked about, and character. What happens when we're getting at this issue? Now, character we know is generally inadmissible under Rule 404 because it's out. But what about the overlap between character and credibility, where we're saying, oh, is there a, does this person have the status of being a liar? This goes to Rule 404A3, which refers us to Rule 608 and 609. And that overlap is the character for lying, that is, a liar or a propensity to lie. And so when you think of the character circle, that's propensity. When you think of the credibility circle, that's to lie. And so the overlap between them is putting them together and say, this person has a propensity to lie. And if they have a propensity to lie, the jury ought to know about that. Okay, so let's look specifically then at the rule, 608 and 609. The starting point really of 608 and 609 is Rule 404A3, which says this is an exception to generally Rule 404A1, that there's no character evidence that's allowed, but you can attack the character of a witness for truthfulness only, and we allow you to do this under 404A3, which refers you to Rules 608, 609, because the 600s deal with witnesses, and so this is the character for truthfulness of a witness. So what we're trying to get at is, does the witness have a propensity to act in conformity with the character of a liar? And if they do, then jury, don't believe them because they are probably lying now. Now, that's perfectly fine. Anytime someone takes the stand, you can attack them. You can't bolster their credibility first. So you can't put a witness on to say how this first witness is telling the truth. If the witness gets on the stand, you can attack their character for truthfulness, and then once it's attacked, then the other side can put on a character witness to say that the character of the witness is actually very truthful. But you can't put on that truthfulness of the character of the witness until their character is for truthfulness is first attacked. You could think of this like opening the door, and if you open the door, the way you open the door is if you take the stand. So if I take the stand, I'm opening the door to have my character for truthfulness attacked. Okay, what does 608B say? 608B says, no specific instances of conduct proved by extrinsic evidence. So it's kind of reminds you of Rule 405A. You can't use specific instances of conduct, but like Rule 405A for general character, you can ask about them. And again, the same requirements are there. In the judge's discretion, there has to be a good faith basis for it, and it has to be pertinent to the character trait. Now, notice the character trait here can only be character for truthfulness. Okay, so now that's where you can ask about it, but you're no extrinsic evidence and you're stuck with the answer. The one time you are not stuck with the answer, and you can use extrinsic evidence of a specific instance of conduct, is if the specific instance is of a crime. And the extrinsic evidence would be the certified conviction records. Then you could use that. So, if it's a conviction, which makes 609 applicable, then you have to ask some special questions under Rule 609. Like, is it a felony, and who is the witness? So, if it is a felony, which makes Rule 609A1 applicable, then you apply the standard Rule 403, right? The Rule 403 standard is if the probative value of the conviction is substantially outweighed by the danger of unfair prejudice, then you would keep it out, right? Now, in that instance, that standard applies only if the witness is a non-criminal defendant witness. If it's a criminal defendant witness, then a completely different standard applies. It's a related but different standard. If it's a non-criminal defendant witness, then your 403 typical standard applies. But if the witness is a criminal defendant, then it's going to be a little bit more difficult to get that conviction in. Because if the witness is a criminal defendant, then in order for the conviction to be held inadmissible, it merely has to be even with or just outweigh the prejudicial effect, right, of the conviction. So those are the two different standards. And if you look at it, this will help to explain it. If we're talking about a regular 609A witness, a non-criminal defendant witness, that's any witness in a criminal case other than the defendant, or any witness in a civil case, the standard is you can use the conviction, but not if the prejudicial effect of the conviction substantially outweighs its probative value, right? So this is going to be admissible, and it continues to be admissible all the way until we get to the point where the prejudicial effect substantially outweighs the probative value. Compare and contrast that now to a criminal defendant witness, which does not apply the regular 403 standard, but applies the modified 403 standard, which says that you can use the conviction, but once the prejudicial effect of the conviction is even with or simply outweighs its probative value, then it's going to be inadmissible. So, given these two different standards, it's clear that a lot more former convictions are going to be held inadmissible when the when the witness is a criminal defendant witness and we're applying that modified 403 standard, rather than when it is a non-criminal defendant witness and we're applying the regular 403 standard. So that's your regular witness. The probative value of the conviction is light, and the prejudicial effect of the conviction has to be very heavy in order for it to be kept out. So it's only when the weight balances look this uneven in favor of prejudicial effect of the conviction that the conviction would be held inadmissible. So many, prejudicial convictions that outweigh the probative value can still come in against a non-criminal defendant witness. It's only when it substantially outweighs it that it becomes inadmissible. So it's admitted unless it's substantially outweighed by the prejudicial effect. Now compare that standard to our criminal defendant witness, where the probative value is merely outweighed by the prejudicial effect. Even that little outweighing, even if it's the same, it's going to be admissible. So the probative value of the conviction is admissible unless it's even with or it's outweighed by its prejudicial effect. So here, where it's outweighed by its prejudicial effect, it's going to be inadmissible. Compare and contrast this to Rule 609B for old convictions, where there's a time limit. Remember, these are thought of as stale, vintage, or old convictions, more than 10 years old. If that's the case, and it's from the time of the conviction or the release, which is ever later. So if the person was convicted 15 years ago, but they served 5 years, then that means, they served 10 years, then that means the conviction would only be considered 5 years old. Even though it was had 5 years ago, the conviction time they spend in jail is still considered. So you can have a 15-year-old conviction, but this time limit wouldn't apply, because if they served 10 years, then it would only be 5 years ago. And so 609 wouldn't even apply. But let's say 609 does apply. Let's say it's a 20-year-old conviction. They served 5 years, so they got out 15 years ago, but that's still over the 10-year time limit. If that's the case, we do the reverse 403 test, where the probative value of the conviction must substantially outweigh its prejudicial effect in order to be admissible. So it's only when the old conviction looks like this, where the probative value of that conviction substantially outweighs its prejudicial effect, is it admissible. Notice in this case, if the prosecution intends to use an old, over 10-year-old conviction, it has to give prior notice to the defendant that it's planning on using an older conviction. So, compare and contrast the two sides for criminal defendant witness and the 609B time limit, right? The criminal defendant witness excluded if the probative value of the conviction is even with or outweighed by its prejudicial effect. But notice, it's even harder to get a 609B time limit in, because there, the reverse 403 has to kick in, where the probative value of the old conviction substantially outweighs its prejudicial effect. Okay, so the balancing test. These are helpful ways to think of it. If you have a non-criminal defendant witness, everything is going to be admissible if the probative value outweighs the prejudicial effect, and even if the balances are all the way like this, it's still admissible. So, the probative value outweighs it, it's even with, or even if the prejudicial effect outweighs the probative value, that conviction is still admissible, because even if it outweighs it, it doesn't substantially outweigh it. For a former conviction to be used against a non-criminal defendant witness, usually it's going to be admissible, but for it to be inadmissible, we have to have this situation where the prejudicial effect substantially outweighs the probative value. And that's our Rule 403 standard. Now, for a criminal defendant witness, in order for it to be admissible, notice that if the probative value outweighs the prejudicial effect, that's going to be admissible. All of those are going to be admissible all the way here, where it's still just barely the probative value is outweighing the prejudicial effect. When does it become inadmissible? When it's even with the prejudicial effect, and then of course anything more that outweighs it or even substantially outweigh it is going to be inadmissible. Finally, compare and contrast that with the Rule 609B, the old conviction, where they're going to be admissible, and that's where the probative value, even if it's even with, and even if the probative value of the conviction outweighs the danger of unfair prejudice, it's still inadmissible. It only becomes admissible when we get this situation, where the probative value of the conviction substantially outweighs the danger of unfair prejudice. And that's the reverse 403 standard. Remember, with Rule 609A2, for a conviction that involves false statement or deceit, and there are rare like perjury or fraud in the inducement or something like that, then even if it's a misdemeanor, it must be admitted. Notice that there is no balancing test, there's no discretion, nothing to weigh. If that conviction is like a super pertinent conviction because it goes right to truthfulness, perjury, fraud in the inducement, that sort of thing, that comes in whether it's a misdemeanor or a felony. All these other ones have to be felonies to come in and then go through the balancing test. But when the conviction involves false statement or deceit, then it must be admitted, no discretion, and no balancing test. Okay, let's stop here, and we'll come back to Rule 611A, which would be form of the question objections.